Just to say that if you are enjoying this podcast and you'd like to give us a bit of extra support, you can head over to our Support Us page where you can give us a tip, or you can follow us on Patreon and you can download our newsletter. And we really appreciate everybody who gives us a bit of extra support there.
Asymmetrical Haircuts Justice Update with Janet Anderson and Stephanie van den Berg.
Hi, Steph.
Hi, Janet.
So, treaty signed. The money's rolling in, or is it? Yes, the Special Tribunal for Ukraine, which we've spoken about at length before, the one on aggression, it's now starting to become a reality.
Money, you've heard about money. There's still a lot of questions about who and where, and some of the what has now been answered.
We were both attending events this month that have provided some insight, so let's get into it.
Yeah, let me start by my event, quote unquote. We went to a super posh hotel in The Hague, Des Indes, where the International Bar Association invited us and a lot of kind of diplomatic delegations and a lot of embassy people I saw around there and Ukrainians to talk on a panel that the IBA put together on this special tribunal. So I got to ask the questions I was wondering about, and they all got to give their side of what had happened.
And here to start with, tell me who you got.
When we were there, I was really impressed with Veronika Plotnikova, who is the head of the Coordinating Center for Support of Victims and Witnesses of the Prosecutor General's Office in Ukraine. And I always like to have, we like to have women's voices on there, but she was very expressive about what victims think of this special tribunal and what really is needed and what she tries to do in terms of outreach.
For this moment, I could say that victims, they are not legal professionals. So they don't know in general what it's all about, because they couldn't identify themselves as victims, or genocide or crime of aggression or war crimes. They are identifying themselves as victims of war. For this reason, every opportunity to talk about these cases, every opportunity to share their experience is crucial for them and really essential. Their expectations are really high if we talk about international efforts. And as I see, it's also our responsibility as a state persons and state representatives to communicate what it's all about, how they could be engaged in all of the processes and procedures conducted by a special tribunal. Let's see. Let's engage victims to be a part of the process. Let's communicate about details, and let's cooperate in this field.
How big are the expectations of the victims? Because if you look at the crime of aggression, the victims are, is kind of everybody in Ukraine is a victim of the crime of aggression. Are they hoping for reparations? Do you have to, is your job to quash expectations all the time?
Management of expectations, as for me, is one of the most tricky things, but also it's one of the most important things in criminal justice and in this process of achieving an accountability for those who committed atrocities. Yes, sometimes we are saying that the main victim of the crime of aggression is the whole Ukrainian society. So all of us, we are victimized in different way or level. We are, as legal professionals, we need to establish a frame who will be victims of crime of aggression in legal meaning, but also, as it was mentioned today on the event, if crime of aggression hadn't been committed, we wouldn't have this huge amount of war crimes and crimes against humanity. So it was a first entrance for these atrocities, committing of crime of aggression. So let's see.
Well, that kind of really helps to set it all up, doesn't it? She put victims and their expectations right in the centre of this debate.
We managed to also speak to André Kostin, who is the former prosecutor general, and we've had snippets of on the podcast before, but is now the ambassador to The Hague. And he is a powerful player. He was very much involved in all kinds of Ukraine lawfare. We've seen him at the ICJ for the genocide case. I've seen him setting up the commission to investigate the crime of aggression at Eurojust. And he was heavily involved with setting up the tribunal. So we asked him why it was so important to have yet another accountability avenue in this form.
Why we deem that all of Ukrainians are victims of the war of aggression or the crime of aggression is that all of us, by different in different way, suffered from this war, and it also explains the core of the crime of aggression as a leadership crime, because the aggression is against not a specific number of people, it's against the full nation.
So I'm going to pick up that particular point, this idea of the crime of aggression as being the crime, the one that encompasses everything and might kind of encompass all victims in some form, which I think would be interesting to discuss. Because if you consider the huge numbers of cases and incidents that the Office of the Prosecutor General is actually investigating in Ukraine, it's going to be impossible for them to actually bring all of those. So maybe there'll be some kind of mass action, some kind of temptation to just roll it all up under the rubric of aggression and end up with everybody being represented at the aggression tribunal.
That seems to be part of what they want. And we're going to get into some of these practicalities and details because I've also asked him this. But first, I wanted to also introduce Mark Ellis, the head of the International Bar Association, because I also spoke to him and he really laid out some of the more tricky technical aspects of the new tribunal and the way that it allows trials in absentia, which was a huge point of contention and still is slightly controversial.
The most important thing is that there has to be a recognition that the accused and who has not appeared in front of the trial has an opportunity for a retrial. But there are exceptions to that, of course. The individual may have, from the very start, have said, "I'm aware of the trial coming up. I refuse to attend. I have no intention of attending." That would be very different. There's no interest. There's no right then, in essence, for a retrial. So the emphasis is here. You need to provide an opportunity for an individual at that point who otherwise did not have the kind of the fair trial right of being in the trial, to have that. To give him that right. And that's all they're doing on this. But there are nuances on here depending on what system it is on that. And you had mentioned earlier about, of course, Ukraine is particularly comfortable with this because, as you say, in Ukraine, as there is in other systems, Ukraine does allow trials in absentia. And when you look at domestic war crimes trials occurring in Ukraine, 95, 97% are trials in absentia. And it's the same reason why I think it was appropriate for the statute of the Special Tribunal for the crime of aggression to permit these trials in absentia, because of the unlikeliness of having these individuals, these very top political and military individuals that were in the position of authority to plan or prepare, initiate, execute these acts of aggression. Chances are those individuals are not going to soon be brought in and apprehended. So for the sake of justice, for the sake of victims, I think allowing these trials in absentia is correct.
Great. I mean, I listened back through to your interview with Mark, and he says so much more in detail on the complexities of in absentia trials. Rather than cutting him down to a tiny proportion, is it okay if we build another pod up around that interview, Steph?
Yeah, I think we really need to use those bits and make a whole trials in absentia podcast. We can also add some of the CONI situations at the ICC where they're also experimenting with sorts of trials in absentia. So we're going to see a lot more of that. So it'll be good to dive in deep, so to speak.
So let's kick off this one about the Special Tribunal for Ukraine, looking at just reminding everybody on some of the big issues. I don't know how Stephopedia this is going to be or whether I'm going to join in some of this before we listen to the main interview with Kostin. What I was conscious of from the discussions in Vilnius is how much compromise there went on. Klaus Kress, the special advisor to the ICC prosecutor on aggression, described it as something like there was a lot of opposition and a lot of difficulty, and then just suddenly everybody said, okay, we can do this in some form. So the negotiations on immunity for the Troika, maybe you explain who the Troika is, and trials in absentia, that was kind of at the heart of the discussions.
There were two very big sticking points. One was whether there is immunity for heads of state, and I think it's functional immunity for the Troika. And the Troika is the head of state, the prime minister, and the minister of foreign affairs. And they have immunity normally under international law, but in some international tribunals, criminal tribunals, remove that and others don't. And then it's a really question about how international is your tribunal that we've also talked about in earlier pods. And in the end, we will talk about what the
compromise
I couldn't think of the word for compromise, which is a very un-Dutch thing of me.
It's part of your DNA, Steph.
Yeah, I would think so, yes. So we'll get into details about what exactly the compromise was. But also there was a big sticking point about trials in absentia, and the tribunal will allow part of this because it is allowed under Ukrainian law, but in kind of American and US law, trials in absentia are really not done. In European civil law, it's much more done. So this is kind of also a mix and compromise issue on that.
Okay, put that marker in that one as we'll come back to it in another podcast. Another issue that I was discussing with people was that, in the statute, the prosecutor is independent, but the actual material and the triggering of the process all comes from Ukraine, and it comes from the Office of the Prosecutor General in Ukraine. So that's a political appointee in Ukraine. So it depends who's the Prosecutor General in Ukraine, what will then be handed over to this independent prosecutor, and therefore what kinds of trials might actually happen.
Yeah, and Kostin, we talked about that, obviously, but also what it struck me how much they want this to be as international as possible. So this idea that, yes, it is the referral from Ukraine that will trigger it, but it is supposed to be independent kind of international prosecutors because they want to avoid any kind of whiff of that this might be victor's justice or partisan justice, or that they're somehow biased for Ukraine. So it really made clear they wanted kind of to be as un-Ukrainian as possible, so they can't get this story that it's biased because it's set up by Ukraine. So they're really trying to distance themselves in that sense from it.
You can see my eyebrows being raised over on the other side of the microphone here. And the other issue that you get into with Andrei Kostin, I think, which is going to be really interesting, is exactly where is it going to be and exactly who is going to be part of this, because there's a lot of different countries in the Council of Europe, but there's also countries outside the Council of Europe. So who's actually going to end up supporting it?
Yeah. So let's go back now to our interview with Kostin and play you a fair chunk of it. I start here by asking him how Ukrainians had to fight to get this tribunal the way they wanted it.
I think first and foremost, what was very important is that it was a joint position of all leadership from Ukraine. That we understood that we need to, in order to investigate and prosecute all types of crimes committed by the Russian regime. This is first very important outset. Second, of course, we have a very strong legal position because it took some time to persuade our colleagues and friends that ICC jurisdiction is not enough. that crime of aggression could not be investigated and prosecuted by the ICC in our case. But it also took some time. Third, of course, there were concerns how this special tribunal, whether it will be a competitor to the ICC. And always it was important to explain in details that it will be not a competition, but rather a complementary mechanism. And this was all a process, of course. And usually it's quite usual to have a resistance when you propose something new. With time, they start to understand that, okay, you are right, so we are right in our endeavor to establish special tribunal. Then you start to discuss details. So first important part of this discussion, or dialogue, better to say, was to have political support from the like-minded countries. And then it was reflected in creation of the core group, coordination group of states, who start to discuss the legal structure of this special tribunal, which was also open a lot of questions to discuss. But it was important to finish the first phase, because some of these issues about whom it will prosecute, the issues of immunities, all these questions were also in the first part of discussion. And this was one of the instruments of our negotiation, saying, look, we need to complete phase first, and then let's start the discussion within the group of legal professionals supported by by diplomats from the ministries of foreign affairs of different member states. So then it actually created several options. And these options not all of them were acceptable for Ukraine. Not acceptable for Ukraine, not because we have other vision, but because we have legal arguments in order to present and to say that, for instance, the so-called hybrid tribunal, which was proposed, that it will not fly because it requires changes to Ukrainian constitution, which is impossible not only to vote because of the martial law, but let's ask Ukrainians, are they ready for such amendments to the constitution, which is a very long and difficult process in Ukraine, and whether we are ready to wait for such a long time, because the idea of such justice mechanisms is to deliver justice in time.
We know in cases before the ICC that often there's a lot of expectation from victims about what could all be possible, and that tends to be slightly squashed because they look at emblematic crimes and only a very few people get recognized as actual victims in that sense, in the legal sense where they can participate in the process. Is your idea or your sense that this tribunal for aggression would also show kind of the state of Ukraine and the people of Ukraine, that the thing that they have suffered from this aggression is being prosecuted, and they see someone on trial for the general aggression that happened much more than for specific atrocities?
Everyone in Ukraine understands that the crime of aggression was committed by the highest leadership of Russian Federation, political, military, law enforcement. It is not impossible, but maybe not practical, better to say, to prosecute hundreds of people in the international justice institution. But the top leaders are alleged, perpetrators are very well known. And if we concentrate on the top leaders, once again, it will be up to the independent position of the future prosecutor of a special tribunal. But we can expect that there will be some concentration on the top leadership, like actually ICC is providing their investigation regarding Russian crimes committed in Ukraine. The approach is to show the pattern of conduct from the highest level, because all other cases are covered by Ukrainian national legal system, and actually highest level as well. But for ICC, it's important to work also as a complementarity mechanism. In our case, it's not just complementing our efforts, because if you have 170,000 incidents under investigation, and even if international justice institution will cover, let's say, 100 of them, so it's not about like real burden sharing. It's more about raising or lifting the patterns of this criminal policy of Kremlin, to show it, to highlight it on international level. And of course, it's also about better visibility and, I would say, joint credibility of our findings. And it was always one of the aims of Ukrainian legal system to ensure the best possible level of credibility of our findings.
And you have managed to do this in a record time, from nothing to a statute in this agreement with the Council of Europe. What is the timeline for getting this tribunal up and running? I assume you would like it as soon as possible. How are you trying to speed up the process in a way?
Of course, it's not only we want, but actually all Ukrainians want for the Special Tribunal to be operational as soon as possible. While of course we need to respect the due process. So the process of creation, the process of starting of its operation should be credible and should be of high conditions, which are relevant to international justice mechanisms and institutions. So as soon as possible, with no compromise to the quality of this mechanism. This is first. Second, how we arrange it, I think this is nothing new. So we are in communication, in constant communication with the potential member states. So most of them are members of the core group. There is a group working in Strasbourg already on preparation. We are in close contact with the government of the Netherlands, because they are on the way of taking important formal decisions. Yes, we hope them to announced also as soon as possible. And then, of course, we will work with also with countries who are ready to join, to do it as soon as possible, because more countries who join this tribunal means, let's say, even less financial burden to cover these expenses. Second, more countries who join means that support or the trust to the results of this tribunal will be more credible from the point of view of international community. And of course, I think more countries who will join, it will also will be a good signal to those who think about starting such aggressive wars in the other parts of the world. That's why it's important that not only Council of Europe member states actively participate in creation of tribunal, but the other countries. That is why the agreement is named Enlarged Partial Agreement. And it's also important that countries from different regions of the world will join, because let's be very frank, it's not an agreement, let's say, which is about some political doctrine. It's an agreement and its judicial mechanism about delivering justice when and where international institutions are not ready to do it. We are not judging why, yes. We are in a situation when we need to propose, and Ukraine proposed this mechanism, and now we are on the way of establishing it.
How important was it for you in Ukraine to have this court in The Hague? Does it lend a kind of extra weight to having a court in The Hague?
I think that traditionally The Hague is the city of peace and justice, and city of several already justice institutions of different kinds, PCA, ICC, ICTY, Kosovo Special Chambers, and others. So first of all, there is it's not only tradition, but Netherlands know how to handle, and they are always proud to host such justice institutions. I think it's quite natural when from, let's say, 5 elements of our web of accountability, which is national investigation, international justice mechanism, bilateral and multilateral cooperation, special tribunal for the crime of aggression, and compensation mechanism, 4 of them should be located, or either are already, or we hope will be located in The Hague. Because it's also about that the elements of this web of accountability, they are interconnected and complementary to each other. As I mentioned, You can collect evidence in national investigation. Later on, it will be used in the investigation, for instance, in Finland or in Poland or in Lithuania or in the ICC or in the United States, as it was the case in 2023. You have joint investigation team under the auspices of Eurojust here in The Hague. Yes, and their findings could be later on transferred to Ukrainian national investigation, as it happens in some cases already. You have ICC, which of course is taking evidences from Ukrainian legal system and from the other member states who are working with us in joint investigation team here in The Hague. And once again, so Special Tribunal for the crime of aggression, there will be mechanisms of exchange of evidences between all these elements with Special Tribunal as well. So not only Ukraine will transfer the case, but the countries who work now at the International Center for the Prosecution of the Crime of Aggression here in The Hague, once again under the auspices of Eurojust, within the joint investigation team, these countries will also have a possibility to share their evidences with the Special Tribunal.
We talked with Mark, and it was touched on yesterday as well, about the immunities. In this statute, you actually don't have troika immunities de jure, but you have them de facto, in the sense that it's not said that there are immunities for the troika, but there is a provision that the judges cannot move forward with the indictment because of this immunity. How important was that, in a way, workaround for Ukraine? Would you have agreed to a special tribunal statute that had immunities for the troika?
I think this was one of the most difficult issues under discussion from the very first days. I will not go into deep details of such discussion that maybe someday we will have more time and ability to make them more public. But at the end of the day, so from scratch, from no, yes, we have, first of all, we have a consensus, and it's in the statute that there will be no functional immunity. That's first. Second, the issue of so-called personal immunity for the members of Troika is divided into two stages, and it's very important. So the full investigation and actually full prosecution process could be completed against them as well. Yes, the court will wait until these persons will lose their position of the members of so-called Troika, and then they could be tried by the Special Tribunal. At the beginning, we have no, and actually it was also no from the very beginning on the trials in absentia, because we need to look at all of this in combination. Because first of all, tribunal can prosecute and try all others. So investigate and prosecute against everyone, including members of Troika, and then start trial against all others in absentia, because otherwise it would be very difficult to explain what is the efficiency. What is the result of this tribunal? Because everyone wants some result. For some reason, you need to explain that justice needs time. And the most important is that justice needs not only time just per se, so just for justice as a process, but needs time to come to a result. And in situation with Special Tribunal, we insisted, and we have been, supported in the end of the day, that first, there could be trials in absentia. It's very important. Second, we can investigate and prosecute everyone. It's up to prosecutor to decide whom to prosecute. And we can try most of them, excluding members of Troika, once they are in this position. And I think that this is the outcome of these negotiations, because at the end of the day, we need this tribunal, Special Tribunal, to be operational. I heard a lot of times a question, Do we really believe that people will stay behind the bars at the ICC or Special Tribunal? And this is quite natural question from people who are just looking at this situation from the side. But for justice system, it's important to collect evidences and to prepare the case. And then history is a very tricky issue. Nobody knows what will happen tomorrow. The most powerful and most dangerous empires can fall in one day after centuries of being, problem for their neighbors and humanity. Nobody knows what will happen. But for justice professionals, for investigators, prosecutors, judges, experts, forensics, everyone who is in charge of justice, the most important is to collect evidence, get this evidence as a system, and prepare the case for trial. This is their task. It's not our goal to try to speculate when and how. Our goal and our main task is to do everything possible for the court to be ready to try everyone who commit international crime against Ukrainians.
And this is a long way away. You're still in the process of setting the tribunal up, but we know from ICTY and ICC that a lot of problems are with who enforces the warrants. If you do have an arrest warrant, do we know who enforces the warrant? If there is an arrest warrant, do the states who sign on enforce it? Does Ukraine enforce it?
This is an issue which will be also regulated in so-called cooperation agreements. This is a very important step which need to ensure that the arrest warrants will be executed. So I don't think that there will be big problems with this because the system is already in place, and I think that it will work like it works now. Yeah, thank you.
Thank you so much, Andrei Kostin, for having a chat to us. I think it's helped us there to get some idea of his perspective on some of the issues. But Steph, coming out of that, where would you say we are now in the process and what is still unclear to you? I've got a whole list that I've written down of stuff that's unclear, but you tell me.
Yeah, there are bits that are still unclear. They have this negotiated statute, but countries still have to sign up for it, and it's unclear to me, and Kostin didn't make it very clear when I asked him about whether that could still be changed or countries could negotiate changes and then sign up. So while it seems like this is the statute and that's going to go on, maybe it can change. I don't know. It's unclear how many states will sign off the bat and how many they get along.
Because that was always an issue as they were doing this kind of core group work where they were going from capital to capital month by month and trying to build up some kind of consensus and momentum around the ideas. I kept on, and sorry about this, but I kept on saying, so are there any African states involved? And there never were, for example. And I think from Latin America, Costa Rica.
There are some Latin American countries, but yeah, I got the impression, I think as did you, that they tried really, really hard to get at least some kind of global representation in that sense. To make it international. And not get this
critique.
Yes, this critique that it is too Western Europe.
And not to get this.
And not to get this kind of critique that it's too Western European or too big powers versus a smaller one or something like that.
I had a quick look, but I haven't gone in detail into how the Council of Europe actually works. And I think we'll have to look at that in more detail ourselves. But I understand that they have things called partial agreements. In this case, it would be an enlarged partial agreement, because this is the way that they have that individual member states can sign up to something, but not everybody has to sign up to it. and non-member states can also sign up to something because it's an enlarged version.
Yes.
And in terms of it being incredibly European or not, I noted when I was noting about money, I did notice that 10 million euros, I think, from the European Commission, I think has been donated. But do we know if there's anything more than that come in?
I think it's apparently up to the countries to see how much they pay. And I wonder what the appetite is for paying for it. Maybe, there you could maybe think that the sanctions against the ICC and the fact that the ICC is kind of under fire might make this more important for accountability. On the other hand, the sanctions against the ICC might also have countries believe that maybe, international justice and putting more money into another tribunal is maybe not it. But 10 million...
You can't say that. You cannot say that in The Hague. I mean, that's blasphemy here in The Hague.
I am channeling the more skeptical people. Of course, I do believe in international justice and all that. But 10 million from the European...
as you say it, Tinkerbell. Come on, we've all got to believe.
10 million from the European Commission is really a drop in the ocean. It's really, the ICC's budget for just 1 year is 160 million euros. There is just no way. 10 maybe you can. What could you do for 10 million?
Well,
Hire a courtroom?
I could do a lot, but
yes.
Yes, I understand these things do cost a lot more. But talking about the Netherlands, did you get the impression from your diplomatic community that you were engaged with there that it's going to be in The Hague? That's what Costin made it sound like. He seems to think it's going to be here in The Hague. Are we going to see prisoners here in Scheveningen?
He really wants it to be, and I think the Dutch government has said, yes, we kind of want it as long as it doesn't cost us any money. So I think one of the big questions is how much money will we raise, and will the Dutch feel that they don't have to spend any of their own money apart from just welcoming it? And that is always the question. But yeah, the idea is to have these prisoners then in The Hague, which that's also going to be interesting. How much more space is there in the UN detention unit? And as we talked with Costin, how many people do you really realistically expect? And we've always heard it's a leadership crime. It's only the top echelons. But when you hear him speak, he's like several dozen. It could be like up to 60 people, which seems like an awful lot for leadership. I don't know.
And another of the questions that I think that we always have, it's interesting if they are going to base it here, because here is where Eurojust has set up the joint investigative team, where we have the ICPA, I forget what the acronym is, but it's the Centre for
International Centre for the Prosecution of the Crime of Aggression,
which is meant to feed in to this. And we have the International Criminal Court based here. But how are they going to have mechanisms? They're going to sign documentation for feeding information one way and the other. Will there be cooperation?
That's always and also with the ICC as it is in the moment, who's going to sign what? Maybe. That's a question. The ICC in the beginning, Khan made some disparaging remarks about having a tribunal for aggression and basically insisting that the ICC could do it if they changed the Rome Statute to include it. But that didn't happen.
But they had the meeting in New York. Of the states parties, and they didn't do it. So
no.
There we go.
And in any case, even if they change it now, it's not going to apply to Ukraine. So I guess then the ICC also knows that that's not going to happen. So maybe they will then be more inclined to cooperate. I did think it was interesting that they said that if there is an arrest or if a person is in the custody of the ICC, then they would have precedence. But
who's the they?
The ICC would have precedence over the Tribunal for Aggression. But that means that as long as they're not in the custody of the ICC, if they have the same suspects for the crime of aggression, and you can have potentially maybe these in absentia, then there might be a kind of tug of war in that sense, where the Tribunal for Aggression will say, well, you can't get them to The Hague, so we'll just try them here, which maybe the ICC will not appreciate. I don't know. It's hard to say.
Or maybe the ICC would appreciate it, seeing as they're going down that road themselves anyway, and it's all grist to the mill. Well, next month, let's have a really deep dive on trials in absentia, and I'm sure we'll come back to the main business of when you and I are going to end up at the inauguration of this new tribunal somewhere in our backyard.
Yes, that should be, I mean, it would be good to have another tribunal here because, you know, it keeps us busy and keeps the podcast full of material. So, yeah, The Hague in that sense.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie van den Berg, in partnership with the Hague Humanity Hub. Music is by Autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.